of the United States Court of Appeals of the 10th Circuit. Please be seated. Morning, everybody. We have 6 cases on the docket, 3 of which will be heard this morning. The first case that we will hear is United States versus Martin. It's 24-3140, and we'll hear from Mr. Bill.
Good morning, and may it please the court. Imagine a newlywed couple decide to establish a joint bank account right after they get married. They're young, they don't have a lot of money, so between the two of them, they make a rule. Nobody spends more than $100 without the other one's permission. But the husband is a golf fanatic. And one day he's at a store and he sees a new putter for $200. He doesn't ask the wife for permission because he knows he won't get it, but he writes a check for $200 and buys the new putter. Has the husband just committed bank fraud? He's a signatory on the account. He's authorized by the bank to write checks on the account. Did the husband lack authority to write that check, or did he abuse his authority to write that check? Ms. Martin was charged with bank fraud because she had the authority to write checks from her employer, was a signatory on the account, but abused that authority to write checks from that account to pay her personal creditors. No misrepresentations went to the bank. She didn't claim that she had signatory authority.
If she had said to the bank, I actually embezzled this check for $1,000. It's not forged. Here's my ID. I want to get $1,000 cash or to put it in my personal account. Would the bank have honored that check? Would it have been obligated, under your view, to honor that check?
I believe the bank's authority in that circumstance, even given that additional information, is simply to compare whether she's a signatory on the account and then honor the check. Now, practically speaking, the bank likely would have made some inquiries in the face of her statements outside.
Well, let's say it inquired and it found out, well, okay, looks like she stole that check, but, you know, she's a signatory on the business account. And so the real question is, would the bank have been obligated to honor that check? And if the answer is no, then she would have obtained that check by fraudulent means against the bank, necessarily.
I think strictly legally speaking, Judge, the answer is yes, the bank would be obligated to honor the check as long as she remains a signatory on the account. The bank's job, legally speaking, is very limited under this circumstance, and if she is a valid signatory on the account, regardless of what happens outside of it, legally speaking, the bank is obligated to honor it.
Would the bank have been aiding and abetting a state crime of embezzlement by allowing her to knowingly to have embezzled money, a state crime, against her employer?
No, Your Honor, I don't think it would have aided and abetted because its obligations are governed by the signatories to the account and what it has to do. At that point, it has an automatic superseding duty to honor the check regardless of what statement she makes when she shows up at the teller window with the check. In this instance, the There's no evidence that any statements about embezzlement or not embezzlement or any inquiry in the bank or communication to the bank happened here, right? This was a simple case of the bank getting checks by an authorized signer and honoring them. Again, no misrepresentations went to the bank, and there's certainly no misrepresentations that went to the bank that caused it to pay the checks that were delivered to it.
Counsel, can I ask you on that point, in the plea agreement, Ms. Martin agreed to certain facts, and one of the facts was that she, quote, used fraudulent pretenses to obtain money from the banks. So how do we square that argument with her agreement that she engaged in fraudulent pretenses if she did nothing beyond just present the check?
Your Honor, I think that I should recognize that's legal language cast in the language of the statute, that fact from the plea agreement. And her agreement to that was based on the deficient advice she got from counsel. We would not expect a layperson to understand the legal implications of that term or that sentence about what she agreed to. And had she gotten effective advice from counsel, then she obviously would not have agreed to that statement in the plea agreement.
Yeah, but how can we conclude that? I mean, Ms. Penner's affidavit makes clear that in her interactions and discussions with Ms. Martin, that Ms. Martin never disputed the facts, that she was obtaining all this money for a personal gain that was beyond the authorization, and to use your words, that she had in terms of those checks. So how can we conclude, looking at the affidavit, that Ms. Martin would have said, well, now that you tell me what fraudulent pretenses mean, there's no way I can agree to that fact?
I think had she been told what the bank fraud statute was required and what the government was required to prove under that statute, then there certainly would have been an objection. I don't think there's a lot of dispute between the parties about the factual underpinnings of this offense. The dispute is whether it was charged as the correct crime and whether that criminal offense, the government could prove the element of obtaining by misrepresentation. And at the very least, Ms. Martin was owed that advice about that element so she could make an informed decision about whether to accept the plea agreement or not.
So your argument is that even if she admitted her conduct, that conduct wasn't sufficient to constitute a misrepresentation under the statute, and she was misadvised as to that aspect of it.
Correct.
She didn't know the impact of the conduct.
Correct. She was never informed that one of the elements of the offense of this offense was that the government would have to prove that she obtained bank property by a misrepresentation that would make its way to the bank. And she was at least owed that explanation of the law before she made a decision about her plea.
You're not suggesting, are you, and I think you're focusing in on Judge Melgren's determination that there was an implied misrepresentation here. So no one suggests there was anything in writing. No one suggests there was any actual conduct other than just the presentation of the check. Is that correct?
Correct.
But you're not suggesting, are you, that conduct could never form a misrepresentation?
Oh, no, conduct can form misrepresentations. There are 10th Circuit cases quoted in the government's briefing where it says presenting an instrument coupled with some sort of conduct can create the necessary misrepresentation. That's just not what happened in this case.
Showing up with the check and standing there with it is not conduct as such.
Correct. There's no additional assertions or anything outside of the check.
The fact that she did this regularly, nothing like that is.
I don't think that there's, given the precedent that a valid check signed by a signatory doesn't contain an assertion, I don't think there's any authority or reasoning that says that cumulative conduct somehow converts what in one instance would not constitute to be an assertion when even one of them wasn't. In any instance, as our brief puts out, the implied authority argument that the government makes has been rejected anytime it's been addressed by the courts just on its own. Certainly there are cases, as Judge Moritz points out, where conduct coupled with presentation would equal a false statement or a false representation. But mere presentation alone by an authorized signatory does not contain some implicit authorization. The most recent case, and I'll supplement it with a supplemental authority letter, was out of the Seventh Circuit just last month in U.S. versus Robinson, 161 F. 4th, 1069, where the Seventh Circuit explicitly rejected the implicit authority argument that the government makes here.
Counselor, can I ask you about your prejudice argument? It seems, make sure I have this correctly, that when you were comparing the prejudice analysis that was done for the tax case counts versus the non-prejudice analysis, what we don't have for bank fraud, I think you made your point maybe in the reply that Ms. Martin says that she would not have gone to trial because any time in prison was too much. It was sort of all or nothing. Is that, first of all, did I sort of correctly frame that?
That she would not have gone to trial, or
that she would have gone to trial, excuse me, because to her, if she had any exposure to prison time, that wasn't going to be worth it for her.
Correct. Ms. Martin's position would have been that if she would not have accepted something that contained the realistic possibility of a term of imprisonment.
So then when we think about any relief to afford to her, we have to find prejudice then on both the tax offenses and the bank fraud count.
Your Honor, I think that because the district court didn't address prejudice as to the bank fraud count, I think the proper course would be to remand it for the district court to examine prejudice after reversing it on its deficient performance. As to prejudice on the tax count, I think the court should remand it with instructions to the district court to use the appropriate legal standard. I don't think that this court is in a position in the first instance to make a prejudice determination on either of those counts.
Can I play devil's advocate with you on the tax count? Mr. Brown argued for affirmance on alternative grounds based on harmlessness, and I didn't see you with a rejoinder in your reply brief on the harmlessness argument. And we do have some cases, published cases, saying that if an appellant doesn't respond in a reply brief to an argument for affirmance on alternative ground, they waive any non-obvious defects in that argument. So have you waived any non-obvious defects of Mr. Brown's argument on the tax count on prejudice based on harmlessness?
I don't think so, Your Honor. I think because this court's longstanding precedent has been on a question that involves facts that you remand to the district court to make the factual determinations. Here, the district court used a flawed, what we consider to be an incorrect legal standard to address the prejudice standard. And so therefore, the overwhelming majority of this court's precedents say that the proper vehicle is to remand to analyze it under the proper legal standard. I see I have 2 minutes remaining, and I neglected to reserve time for rebuttal, so I'll do that now, unless the court has any other questions. Thank you.
Good morning, Your Honors. James Brown for the United States. Your Honors, this court says that for counsel's advice to be deficient under Strickland, it must be completely unreasonable. Counsel's advice in this case was not completely unreasonable because it was consistent with this court's own interpretation of 1344-2, as well as this court's case law. In United States v. Kane, this court said, quote, a defendant's misrepresentation to a bank that he or she is authorized to engage in a particular transaction may constitute a violation of 1344-2. That language applies to defendant's conduct in this case, and that language in this court's case law provided an objectively reasonable basis for counsel's advice. Now, could counsel have been more imaginative and advised defendant about all the potential defenses or novel defenses or his interpretation of Lawfren? Yes, but counsel is not required to advise of all potential defenses or novel defenses or unsettled defenses. Counsel's advice just has to be within prevailing professional norms, and that's what.
Oh, you go ahead.
And that's what we have here.
Let me play devil's advocate with you, Mr. Brown. Now, we do have cases saying that counsel isn't necessarily unreasonable or deficient in failing to present every plausible argument, but Judge Ebell wrote an opinion in Hurd versus Addison that said that at prong one, counsel was deficient because the argument that counsel failed to advise the client about was a very strong argument. And so it seems to me that there's a continuum. If it's just simply one of many possible arguments, maybe counsel isn't deficient, but under Hurd, if it takes on if it's a powerful, good argument, you'd have to acknowledge that counsel was deficient in failing to advise counsel of a client of a good argument, right?
In most cases, we would be constrained to agree with that, but we would also respond that this was not a very good argument. It was hardly even a colorable argument. In fact, I don't even think it's a colorable argument when you look at this court's case law. And the Kane statement that I just quoted, that basically applies to counsel's conduct. And then you have 4 cases from this court where we have implied misrepresentation cases. And I'm referring to the McDonald case, the Briggs case that was cited with approval in McDonald, the Morgenstern case from the Second Circuit that was cited with approval in McDonald, and then the Adams case from the District of New Mexico. Each of those was an implied.
And they were all pre-Lawfren, and McDonald was unpublished, 2006, right? And so then the other case that was pre-Lawfren was relying on this unpublished pre-Lawfren case, McDonald, right? You haven't cited anything after Lawfren.
Well, that's correct, but let me discuss those cases, and then I'll get to Lawfren.
Why don't you discuss the post-Lawfren cases from other circuits, such as the one that was just mentioned, or the McDonald case from the District of Virginia, where the court has very clearly said, yes, there is no such thing as implied representation in this very scenario. I mean, those are post-Lawfren cases. Both are published. That by itself, and they relied on Lawfren. That by itself should be evidence that this was certainly a plausible defense. It's been made and accepted post-Lawfren very clearly. And I think you can read the language of the statute and see that it's a plausible offense. So why was it reasonable not to do that, to read the language of the statute, to think about this in terms of the facts that were before this, with this attorney knew, which is that she was a signatory and had authority to write those checks? Why was that not a plausible and complete defense that should have been considered?
2 responses, Your Honor. The first is with regard to the court's questioning about the McDonald case cited by the defendant. That was decided on May 24.
I understand that, but it was decided based on Lawfren.
Well, but
And my point is, this court Judge Melgren could have done the same thing had someone presented him with the Lawfren case and made that argument.
Well, but we look at whether counsel's advice is deficient in light of prevailing professional norms. And when counsel advised defendant of this, that was not part of the prevailing professional norms because that case was not decided.
It wasn't when this case was decided either. The point is somebody's got to make the argument, but that doesn't make it a novel argument. The fact that no one's made this argument post-Lawfren doesn't make it novel or implausible.
Well,
this is a very plausible argument that just wasn't made.
Well, we don't agree that it was a plausible argument that just wasn't made. Counsel was not completely unreasonable for not making that argument.
I didn't say counsel was completely unreasonable. I'm saying it was a plausible argument and it was a complete defense.
If counsel was not completely unreasonable, there's no deficient performance. Now, with regard to Lawfren.
Completely unreasonable is the standard in terms of not raising a defense.
It is the standard. This court says that for counsel's advice to be deficient under Strickland, it must be completely unreasonable. Here,
well, what is completely unreasonable when a complete defense is potentially obvious from the language of the statute itself and post-Lawford, which was decided in 2014, is clearly an available argument.
Well, the court keeps saying.
What is completely unreasonable?
Well, it has to be, like Judge Baccarat said, we can look at things on a continuum. At the time of counsel's advice, no court had decided that. That was a logical reading that he infers from Lawford. Lawford didn't say that. Lawford was not an implied misrepresentation case. And that's why it's distinguishable. It didn't address checks submitted under false pretenses. That's what happened in this case. So a reasonable counsel could look at this and say, hey, Lawford didn't address a check submitted under false pretenses as this case does. In Lawford, the checks were altered or forged. The falsity was facially evident from the check. That was the false statement. A false pretense is a fact that is not disclosed, where somebody has a duty to disclose it. She didn't disclose that she didn't have the authority from her employer to write any of these checks, and she had a duty to disclose that. Like Judge Baccarat said, if she had gone to the bank with a check and said, I don't have authority from my employer to draw this check or cash this check, that would not be a false pretense. But she had a duty to disclose that. She didn't.
What about the fact that we've defined false representations consistently as either express, stated, oral statements, or not implied conduct, never said implied, but conduct, actual conduct of some sort.
Well,
We've never, that I've said, really studied this idea that Judge Melgren came up with, or that was presented to him that by the government, that some sort of implied representation, no physical manifestation of that in any way can constitute a false misrepresentation under this statute.
Well, we would disagree that the statute does not include implied representations because the statute uses the term false pretenses.
Well, are we talking about?
A false pretense is an implied misrepresentation.
Okay.
Do
you think pretenses and misrepresentations here are one and the same?
No, false pretenses is distinct. False pretenses is an implied misrepresentation or an implied false statement. A false representation, on the other hand, is an express misrepresentation. And I get that from the Baumgartner case that we cite in our brief. There are two distinct things, and this court has used implied false representations in 4 cases. Well, in one case, McDonald, it talked about implicit false representations. In Briggs, which this court cited with approval, talked about implicit misrepresentations. In Morgenstern, they were implicit misrepresentations. In the Adams case, the checks were perfectly valid, but there were implicit misrepresentations. So counsel could look at these 4 cases and say, hey, and the statement that I just quoted in Kane and say, hey, this is a false representation case. The Lawford case doesn't cover false pretenses, doesn't cover false pretenses. There's 4 cases that do cover false pretenses, and those cases fit the facts of my case. And then I have the statement from Kane that I have to consider that comes directly from this court. How does counsel make an unreasonable decision not to advise defendant about the defense that was basically first stated in a case decided 1.5 years after the defendant entered her plea?
Counsel, can I ask you, though, about the evidence that we have before us, and Ms. Penner's affidavit in particular? As I read the motion to vacate, Ms. Martin says explicitly that she was not told that the elements required that she use deception as a way to obtain bank property. And then I look at the affidavit, and Ms. Penner doesn't really take on that element at all. She talks generically about the facts and the evidence meeting the elements, but she doesn't discuss this particular theory of defense at all. It's alleged in the motion to vacate, and there seems to be then some gaps then in whether or not she's even rebutting that allegation. Am I reading that correctly?
Maybe, maybe not, depending on how the court interprets what I'm going to cite at Record Volume 1, page 162, where Ms. Penner states that the defendant wrote numerous checks that named her as the payee, which resulted in funds being withdrawn from the employer's bank account. She did this without authorization, and in doing so, misrepresented to the employer's banks that she was authorized to receive the funds. So there you have Ms. Penner talking about the misrepresentation, the implicit misrepresentation.
She also, though, says that she doesn't talk about case law or review the applicable PIC instructions with her client. And that kind of stood out to me. I mean, I'm a Kansas lawyer, and this is federal court, and typically the instructions we come up with for federal offenses are not from the patterns instructions in Kansas. So at least gives me pause as to whether or not Ms. Penner is even rebutting the allegation made.
Well, she looked at the statute, which talks about false pretenses. She concluded that the defendant engaged in false pretenses or implicit misrepresentations to get the money, and we think that that sufficiently shows that her advice was not completely unreasonable, even if she didn't cite any cases in her affidavit or consult a PIC, as the court points out.
How do you read the district court's order, though, to not hold an evidentiary hearing? Judge Melgren sets out the standard, but doesn't actually, as I read it, explain why he doesn't hold a hearing. So how does the government read that?
The only way we can read it is that counsel's affidavit said that basically the defendant had no memory of the offense anymore because she had a stroke. And what would be the point of having an evidentiary hearing? You couldn't put on the defendant because she would just say that she can't remember anything from the offense. So what would be the point? The court just looked at the offense, but also it's probably an easy case for the court because these are implied misrepresentations. There's 4 cases on point for implied misrepresentations. The statute talks about false pretenses, and false pretenses are implied misrepresentations or implied false statements. So the court probably thought this is an easy case on the law, and that's the only thing that's an issue. And the only case the defendant cites is a case cited a year and a half after the defendant entered her plea, keeping in mind that counsel's advice only has to be reasonable under prevailing professional norms. And at the time, counsel was not required to read Lawfren as even addressing false pretenses or implicit misrepresentations. It wasn't even applicable. Now, could counsel have been more imaginative and thought, hey, I can say that Lawfren really does address false representations or false pretenses, even though it doesn't talk about them, and I can say that because this wasn't an express representation, it must apply, and I can say this, that, or the other thing. But that doesn't mean that counsel's advice under prevailing professional norms was unreasonable.
What about, Mr. Brown, a check kiting scheme? Let's say hypothetically, I decide to supplement my income by running a check kiting scheme. And I've got an account with Oklahoma Bank. Have I committed any implied misrepresentations or explicit misrepresentations to the bank?
Well, you know, the court is probably trying to trap me with the Williams case.
Well,
and
gosh, I am not that devious. Mr.
Okay,
Brown.
okay.
I asked you a question.
That being said, it's not a false statement for 18 U.S.C. 1014 under Williams. Is it a false representation? It might be. It might be a representation that the funds are actually there. I mean, or that the drawer promises to pay those funds.
So it is a fair inference that it is a misrepresentation?
For the bank fraud statute, not for 1014, which is the false statement statute.
So why in footnote 4 of Lawfren did the Supreme Court say that every single circuit court to address the issue has found that a check kiting scheme does not violate 1344 paren 2?
Well, you know, that's what the court was saying, and they were saying this within the context of the false statement statute and whether an insufficient funds is a false statement statute. You know, and I understand what the court is saying, but I'm saying that there's another way to look at it, and I can't explain why every other court did that, but I can see the court's point. It's very well taken, but I don't think we need to get there.
Slow down. We'll give you more time, as much time as you want. I'm not trying to trick you. I'm really not.
I was just joking, actually.
I know, but I'm not, I mean, but I'm just really trying to ask you a question, and I'm not sure that we're communicating. So I just wonder if this is a misrepresentation, and if the Supreme Court implicitly is saying every single circuit court to address the issue has found that scheme, despite the implicit misrepresentation that's inherent, does not violate the very statute that we're talking about, 1344-2. I'm really trying to figure out how do I reconcile footnote 4 with your argument.
Well, you know, I would have to look at the cases that the court is citing. I haven't looked at those cases or looked at the basis for those courts' decisions. The court can, I suppose the court can say that if somebody writes a check for $1,000 and they have $10,000 in their account, is that check a false statement? That check basically promises whoever the payee is that they have $1,000 in their account because a check is a promise to pay. Is the promise to pay a misrepresentation? It could be. Is it a false statement? No, because Williams says it's not a false statement. If the check is forged, then we know it's a misrepresentation or a false statement under Lawford, right? So there's some argumentative wiggle room there, you know, to flesh out exactly what is what. But here, all we have to know, we have to decide whether counsel's advice was completely unreasonable. It was not completely unreasonable under Lawford. It was not completely unreasonable in the 4 cases that I've been talking about. It was not completely unreasonable under the plain language of the statute, which talks about false pretenses.
What about Williams? Now, it's an old case, but doesn't it say that a check doesn't contain any representation whatsoever? It can't be true.
Counsel was not required to give any credit to those statements because, number one, that was an 18 U.S.C. 1014 case, and number two,
Since when
and
does
we're
that
under,
matter?
and we're
Since when
under,
does it matter? Since when does it matter that a statute that is an entirely different statute but might contain a similar false misrepresentation type
well, it matters.
aspect that would clearly apply to this statute, or might clearly apply, and people have been making that argument.
It matters.
And winning. As defense counsel, can you just kind of put blinders on and say, well, I'm going to look at this statute, but I'm not going to look at anything else that could be related in the bank fraud area, because I don't need to look at those to represent my client adequately. Is that what you're saying?
To that, I would say look at footnote 5 of our brief, where the Lawford Court uses the term false statement and false representation repeatedly to describe a forged or altered check. The Lawford's use of that term to describe a check is exactly contrary to Williams. That's why counsel was not unreasonable in not relying on Williams, which addressed a different statute. Apparently, the Supreme Court thought the distinction mattered because they said a check can be a false statement or false representation under 1344.
I agree there may be some inconsistency between Williams and Lawford.
And counsel was not unreasonable for saying, there's an inconsistency here. I'm going to go with
But we
1344.
don't even know that, I mean, I guess I'm saying to you, we don't have any idea if there was any attempt whatsoever for counsel to even, counsel even made any evaluation. Based on her affidavit, we certainly don't understand that. And what, you're basically saying it's totally reasonable for counsel to consider all of these things and then rule them out. That's not really the standard, is it?
Well, the standard is whether counsel's advice was objectively clear, completely unreasonable.
And there was no advice here, apparently.
There was
At all.
advice. There was advice. If you look at the affidavit, that they talked about the elements and she talked about misrepresentations, and she thought that.
Yeah, no advice that this may not be a misrepresentation, that her conduct might not form a misrepresentation under this statute. No advice like that, and apparently no consideration of that.
There had to have been some consideration of it because we have counsel's representation in the affidavit that she considered that the defendant made misrepresentations and she defrauded the bank by false pretenses.
She accepted, counsel did, that those misrepresentations apparently were sufficient.
She thought
Implied misrepresentation.
she thought they met the definition of false pretenses, and that's what the statute criminalizes.
Okay.
I see my time is up, and I thank the panel for the extra time. Thank you.
Mr. Bell, I just want to tell you, it was in a moment of temporary insanity that I told Mr. Brown that you could have as much time as you wanted.
I was going to insist on equal treatment.
I know, and that's why I wanted to plead insanity to that.
I think Judge Moritz's last exchange with the government really encapsulated the issue, at least as it goes to the bank fraud, is that, you know, right or wrong, whether it ultimately would have prevailed or not, it was a plausible defense and Ms. Martin should have been informed about it before making a decision about how to plead. And just to give some context about whether it would have been obvious or should have been obvious, in that Robinson case from the Seventh Circuit that I just mentioned, the Seventh Circuit found it was plain error for the district court not to sua sponte enter a judgment of acquittal based on the same facts. So just to give you an idea of how obvious it was, and I can't substitute my own experience or judgment with anybody else's, but just looking at the Loughran case, it doesn't seem like there has to be much extrapolation from the statements of the Supreme Court there to Ms. Martin's case to realize Loughran gives you a viable and complete defense. I mean, the statements in Loughran are on the head saying this is what is required for a conviction under this statute. And it's not necessarily phrased in murky 19th century language either. It's pretty stark.
Isn't there a conflict between Williams and Loughran in the sense that Williams said there's simply no factual assertions at all in a check? There's nothing that can be characterized as true or false. And yet then you have in Loughran, the court saying, well, yeah, at least the signatory aspect of it can be a misrepresentation. True or false that you have authority to, as a signatory. Isn't that inconsistent by itself?
I think at first blush, yes, but putting them in context, no. When I see I'm about to elapse my time, so if I could have some time to respond.
Sure.
Thank you. The context of Williams was in a check kiting scheme, right? So in that case, the court's dealing with checks that are signed by a valid authorized signatory, right? And so just the face of the check, this is a command by a valid person to transfer money to this other party. There's no statement of fact within there. A forged check, though, is different because it itself is false because the person is purporting to be someone they're not and have the authority to command the bank to transfer the funds. So I think once you put the context of what Williams and his progeny were into, I don't think there's a conflict
I
between
get
the
the
two.
context. I just think the statement was broader, as I read it in Williams, maybe than it needed to be.
It would have been better if there had been some explanatory clause in the beginning of the no check can be a false statement. But I think in the context of what they were dealing with, it's clear that they're talking about, under those facts, by an authorized signatory and everything else. The check isn't altered, it's not forged, right? On its face, it's a valid instrument. All right. All right, thank you very much.
Thank you. It's very well presented by both sides. And by the way, Mr. Bell, do you think in the next, say sometime in the next 3 days, could you give us a 28J letter with that, I guess it's that Seventh Circuit site? And can you do me a favor and not include a whole bunch of argument? All we need is that site.
Point taken.
All right, thank you, counsel. The next case is Lewis versus U.S. 25-1036. Just give me a kick.
Will do.
I think whenever you're ready.
Good morning, Your Honors, and may it please the Court. Michael Kuhn on behalf of Appellants Kate and Jeffrey Lewis. I'd like to reserve 2 minutes for rebuttal. Ms. Lewis has terminal metastatic breast cancer because her medical provider failed to diagnose the malignant tumor. She pursued a claim against the United States and complied with every timing requirement under the Federal Tort Claims Act. But according to the trial court, Ms. Lewis can't bring a claim against the United States because she discovered her cancer 32 days too early, triggering Colorado's medical malpractice statute of repose. The trial court's grant of summary judgment is wrong. It rests on a misreading of the Colorado's statute of repose, reopens constitutional issues addressed by the Colorado Supreme Court, and resolves disputed material facts that must go to a jury as to when Ms. Lewis discovered or should have discovered the nature, extent, and cause of her cancer. But more fundamentally, Colorado's statute of repose is conflict preempted by the Federal Tort Claims Act as applied.
So in other words, only if we adopt the district court's interpretation of the statute of repose is it preempted?
Correct, Your Honor. And the rule that we're advocating for today is a narrow rule, and I'll explain that further. I mean, we submit and we argued below that state statutes of repose are always conflict preempted. But the situation here involved kind of a unique set of facts where the claim accrued shortly before the expiration of the statute of repose and where there was insufficient time to comply with the 6-month requirement. So the FTCA, in Congress in passing it, created a framework that favored the administrative resolution of claims. And in that vein, Congress said that plaintiffs, before you can sue the United States, you have to file a claim with the agency, give the agency at least 6 months to consider it. And as this court noted in Lopez, that rule has very important underpinnings, and that is it gives the agency notice of a claim, an opportunity to investigate, and a chance to settle it outside of litigation, which was Congress's preferred method for resolving claims. Colorado's statute of repose creates a material impediment to that administrative process, and as applied here, made compliance with the two statutes impossible. Allowing a state statute of repose to short-circuit the FTCA's mandatory administrative mandatory administrative process, shortens the presentment period, pressures premature filing, and undermines Congress's settlement-focused scheme. Congress did not create the administrative process to operate under the constant threat that state law would extinguish the claim before the process could even conclude. This case illustrates the point. The trial court found that Ms. Lewis discovered her cancer on December 31st, 2019, and that the statute of repose expired February 1, 2020. So even if Ms. Lewis had filed an administrative claim the very day that the trial court held that she had discovered her cancer, she still could not have pursued it against the United States, whereas a private person in that circumstance could be liable. Now, we acknowledge that no circuit court has held that the FTCA preempts state statute of repose, but we submit that a narrow rule that would hold that state statutes of repose are preempted in those rare cases such as Ms. Lewis's, where the statute of repose extinguishes a claim when there's a short period of time after accrual.
Well, and Congress said in the FTCA statute that, you know, if private persons, if there's no liability against a private entity, then there's no liability against the government. Did they indicate any exception to that rule? I guess I understand your argument, but I don't see how that really comes into play.
Your Honor, Congress...
That just fundamental sense of fairness and that it's contrary to everything the FTCA is about. But the FTCA contains this provision saying if a private entity can't be liable, neither can the government. And it doesn't say, unless it's not very fair for that to happen, which is...
Your Honor, we're not relying on express preemption. We're relying on conflict preemption.
Yeah.
And our argument is that Congress, in passing the FTCA, supplied its own deadlines. We're dealing with a statute of repose here for what I would term as not core substantive. It doesn't deal with elements of liability, standards of care, damages, theories, and the like. But when it comes to conflict preemption, you can also, I think that the point you're making highlights the impossibility concern. Sitting on December 31st, 2019, had Ms. Lewis been with a private provider, she could have sued them, in theory. She could not have because she had a claim against the United States and was required to go through the 6-month administrative process. And so there's an impossibility tension there where she could not have pursued a claim even if she wanted to.
You didn't make any argument below, did you? And I think you're not making it on appeal, that this is simply not, in the context of this Colorado statute, it's not a substantive
Your Honor,
statute of repose. I mean, it's part of one section. It's essentially a unitary statute of limitation. And when you get to the exceptions, it refers to the limitation of actions provided in subsection 1 when it's suggesting that the statute of repose isn't going to apply, indicating that the statute of repose is part of a unitary statute of limitation.
Your Honor, we conceded below and on appeal that the statute of repose here is substantive.
Yeah, I'm wondering why you did that.
Because there was, I think the great weight of cases across the nation hold that statute of repose is unlike.
Don't you have to look at the statute in this case, not generally statutes of repose, the statute in this case and how it is designed?
And Your Honor, I think there was discussion in Judge
This
Wall.
isn't just some general statute of repose. This is a statute of repose in Colorado for medical malpractice actions, and then there are these exceptions.
And again, Your Honor, that point was not argued below, so we didn't brief it on appeal. I would say, though, even if we concede that it's substantive, a substantive law from our view can still be conflict preempted when it undermines a central pillar of the FTCA, specifically the administrative process. And so when you look at the circuit court cases that the United States have relied on, I don't believe such a rule would be inconsistent with those cases insofar as Baldwin and Smith were very brief, unpublished decisions that didn't address the issue. Agudas, Huddleston, and Anderson all involved plaintiffs who, in theory, could have complied with both the statute of repose and the 6-month administrative requirement. In other words, there was at least 6 months remaining upon discovery prior to the expiration of the statute of repose. But then that leaves Bennett and Jones, but in those cases, the statute of repose had already expired prior to the accrual of a claim. But Bennett is useful in one regard. The Ninth Circuit, in saying that the statute of repose is basically incorporated as substantive law, in footnote 9 left open the possibility, what it termed as an equitable exception or a different rule that might apply when a claim accrues shortly before the expiration of the statute of repose, and the administrative process would be frustrated thereby. Well, Your Honors, we're here today on those facts, and we think that the court can create a narrow rule consistent with footnote 9 in Bennett.
Counsel, can I ask you about the accrual date? Do you view that as a question of fact?
I do, Your Honor, and that is another very simple way this court can reverse the trial court's grant of summary judgment. The relevant date here is February 1, 2020, when the statute of repose, according to the trial court, accrued. So even if we accept the trial court's reasoning on preemption, we accept its interpretation of the statute, we still contend that there were material facts of events that occurred post-February 1, 2020 that create a tribal issue of fact as to whether Ms. Lewis knew the nature, extent, and cause of her cancer.
So you would say or agree that if we found there is a dispute of material facts, so summary judgment was not appropriate as it relates to the accrual date, then your as-applied preemption argument may not need to be reached?
Absolutely, Your Honor. The court can easily resolve this case on summary, and there'd be good reason to do so. Sitting on January 31st, 2020, all that Ms. Lewis knew at that point in time is that she had breast cancer that had metastasized to a single lymph node. She had yet to meet with an oncologist. She didn't know whether the cancer would be life-ending. She didn't know.
Why does any of that matter?
Because, Your Honor, the Colorado Court of Appeals decision in Liscio versus Pinson is why. And what Liscio versus Pinson says is that when you look at knowledge of an injury, what is required is knowledge of not only the nature of the injury, but also the extent of the injury.
Well, okay, fine. So on February 1, 2017, the nurse looks at her lump and says, it's fine. No problem, nothing to worry about. December 31st, she realizes she has cancer. January 31st, she realizes it's metastasized. Okay, well, she thought on February 1, 2017 that she had nothing to worry about. She knows that she has now cancer. It seems to me the $64,000 question is whether or not the cancer that was detected on December 31st, 2019 was the same lump that she thought was nothing on February 1, 2017, but you haven't made that argument.
We have, Your Honor, and I think that argument was made below specifically. You know, the trial court viewed the question of accrual through the lens of worsening of the condition. Well, there was no evidence to show that between what Nurse Trexler failed to diagnose in 2017 and February 1, that condition had worsened. So I think that there's a distinction between the worsening of what was then thought of a benign cyst is quite different than the worsening of terminal cancer. So I think when you look at it through that lens, and the McCullough case out of the District of Wisconsin, I think, addresses that. There was no evidence to show that there had been a worsening of the cancer between that time. And on summary,
I'm not 100% sure that if I'm correctly interpreting what that argument means. Are you saying that on the 11th of February, when she sees the oncologist, that the oncologist is the first time that anybody ever tells her that this problem, this cancer, this metastasized cancer in your breast is exactly what Nurse Drexler looked at 3 years and a couple of months ago?
Your Honor, there was no specific statement in that regard during the meeting. Now, the appointment she had with her oncologist was a lengthy appointment. The notes were exhaustive. But
Was that the February 10th?
February 11th, I believe, or 10th, yes.
Yeah.
That I think on summary judgment and granting Ms. Lewis all favorable inferences, that we can assume that that may have been discussed as to likely, you know, the origin of the cancer, the development that it had done, and the progression and the likely treatment Ms. Lewis would have to undergo because of it.
Well, you don't pay much attention in your briefing to what happened in between the February 1st and 2017, December 31st, 2019. But in between there, didn't she have a mammogram and an ultrasound that would have been read by a radiologist, another doctor who sat looking at that, apparently that same,
She
what
absolutely,
they thought was a cyst,
she absolutely
looking at
did.
that same, telling her, nope, nothing there.
But if
Nothing
anything,
there. And doesn't that actually support you? I guess I'm not understanding.
it
why
does
you
support
don't-
it, particularly the
Why
cause.
don't you rely on that as much as you rely on these dates to say, at what point would she have known that the February 1st, 2017 diagnosis was wrong, much less the 2018 or whatever year that was?
And we made that argument below and in our brief, and particularly that
I
goes
see
to,
a focus on what happened in between.
and particularly it goes to causation. So, I mean, all throughout this process, Ms. Lewis's medical providers are telling her it's of no concern, nothing to worry about.
The same lump,
The same,
same lump in her left breast.
yes.
Yeah.
And so we think that at a minimum, there are triable issues of material fact. And yeah, sure, reasonable minds can disagree as to whether or not Ms. Lewis knew of the nature, extent, and cause of her cancer sitting on February 1. But it wasn't for the trial court to resolve that issue on summary judgment. And so this court can simply avoid the preemption argument. It can avoid the statutory construction and potential constitutional questions under Colorado state law by simply resolving on summary judgment. And with that, I would request to reserve the balance of my time, unless the panel has any additional questions.
I do, but Robert, why don't you stop this clock, okay? I'm not cheating you out of your rebuttal. I have a question for you.
Can I go as long as I would like?
No. I'm only insane once
A moment of
term.
insanity.
Once a day. And Mr. Brown already got my moment of insanity. So I have a question, though. So on this, in your interpretation of 3C, as I understand it, you've got two separate arguments. One is that it's an exemption. If the injury wasn't immediately known on February 1, 2017, then this statute of repose is inapplicable. But you also interpret it, as I read your briefs, as like a tolling, the equivalent of a tolling provision. So in other words, that 3-year statute of repose would only begin on, say, December 31st, 2019. Which of those is your argument?
Well, I think it's primarily that what it does, subsection 3, is create a discovery rule.
So you're not arguing that if she didn't know on February 1, 2017, you don't have to worry about a statute of repose?
Well, I mean, the two kind of collapse on each other. If she knew on February at that point in time, the discovery rule would have just started at that point in time. And so our argument is this, that subsection C, the trial court added language that wasn't there to say that it has to be discovered within the 3-year period. And I would submit, Your Honor, that Colorado statute of repose, it's not a traditional statute of repose considering the context in which this exception came about. And I don't want to abuse the additional time that you've given me, and so I'm happy to take the additional 32 seconds I have prior to my rebuttal, just briefly explaining that. And that is, originally the statute had A and B for knowing concealment and foreign objects, and then the Colorado Supreme Court comes out with this opinion and—
Can I stop you? Because you are going to get your rebuttal, but I'm still not sure that I understood, and I probably just missed it, the answer to my question. So I just want to know, door number A. There used to be a show called Let's Make a Deal. You're too young to remember it.
Monty Hall.
Money Hall, okay, you're older than I thought you were. So door number 1 is an exemption. She didn't know on December 31st, on February 1st, 2017, about an injury. You never will address this statute of repose because she didn't know on that day. Door number 2, Money Hall, says, well, it begins on December, that statute of repose begins on December 31st, 2019. Am I right that your argument is door number 2? You're not arguing door number 1?
I'm not, Your Honor. I think when you look at the plain and ordinary language of the statute, that's what it says. Now, what I think to the extent there's any ambiguity, this court's starting point has to be the Colorado Supreme Court's decision in Austin versus Litvak. And what the court there said in a plurality opinion was that, the original statute only had A and B for foreign object and concealment cases, and the Colorado Supreme Court in a plurality opinion said, look, 3 of the justices said it violates the Equal Protection Clause of the state constitution to fail to give the same benefit of a discovery rule as they have for A and B, to negligent misdiagnosis. The 4th justice, Justice Dabowski, she says that, look, it violates a separate provision of the Colorado Constitution anytime you employ a statute of repose to foreclose a claim when a plaintiff doesn't have a meaningful opportunity to pursue it. So then the legislature passes and adds this subsection C to address that. So I think
Is there any legislative history to show that that's what they did?
There was none that was addressed on that and how this came.
A lot going on in that time.
I mean, there was.
Statute
You had the
changed.
tension between the tort reform movement
right,
and the Colorado Supreme Court, which was opposed to much of that. And so I think that what we have to do is we say, all right, well, sitting here today, negligent misdiagnosis plaintiffs under the trial court's interpretation of the statute do not have the benefit of a discovery plus 2 years, which A and B unquestionably do. That would certainly trigger the concern of 3 of the justices. And as to Justice Dabowski's concern, I don't submit that anyone would say 32 days is a reasonable period of time to pursue a claim. And so with that, Your Honor, I will reserve the balance of my time.
You can answer as much as you want.
Extend your.
You can answer as much.
I'm here all day.
I do have a question about what I think is a mess in terms of this statute itself, and I thought your request to certify was apparently not well taken because it came late, but this strikes me as a potentially certifiable case.
We would have no objection to certifying it to the.
In terms of the interpretation of the statute, because, for instance, the Colorado Supreme Court, to me, seemed to recognize in the 2 cases that have considered this issue, the misdiagnosis issue, Comstock and the other, trying to remember the first one. Austin, yeah. They recognize that Section 3, which contains the limitations now, A, B, and C, when it says the limitations of actions provided in subsection 1, they recognize they weren't just talking about the limitation of action.
No.
They were talking about the repose limitation. So they recognize that at least with A and B, the limitation of action, if you apply exceptions A and B, there is no
There is
statute of
no statute, and that's the issue.
Why would it be any different on C? Why would you?
Well, it
why-
has to
C
be.
said- Right. Well,
Under the
that's what I'm
constitutional
asking
avoidance, if
but-
you don't interpret it
But
that
nobody
way.
seemed to be, the district court didn't really point that out, which A and B, it's accepted that there's no statute of repose, but the same language in 3 applies to C, which is the limitation of actions provided in subsection 1 do not apply. So how do we get any aspect, any portion of the statute of repose applying under C?
I don't believe we do, and I think that interpreting that manner is consistent with what the General Assembly did to comply with the commands of Austin versus Litvak.
Maybe.
I mean,
But
and I
maybe
agree
they
that
saw- Maybe they saw Austin v. Litvak as a plurality opinion that had no.
we agree the statute is a mess, but again, the starting point for this court's discussion should be Austin versus Litvak. I understand that there are probably reservations as to the rational basis analysis, but as it goes to the state constitution, we need to defer to what 3 of the 7 justices said in that regard and view Austin versus Litvak.
Thank you.
Thank you.
See, you ended up getting as much time as you wanted anyway.
Probably a little bit more.
May it please the court. Elizabeth Ford Milani on behalf of the United States. The FTCA incorporates, not preempts, Colorado's statute of repose. That statute of repose sets a hard deadline. The Lewis's claim was extinguished 3 years after Miss Lewis met with nurse practitioner Trexler. That hard deadline was not met. And the
Only if
exception,
section C applies, doesn't apply.
if,
Only if subsection C doesn't apply.
correct. The
And
subsection
could you-
C does
could
not
you
save them.
Answer that question that I just asked because it's fresh on my mind, and I apologize for interrupting so quick. But
Certainly.
I don't want to lose that train of thought, which is why would section C possibly have a partial statute of repose built back into it when section C is subject to the same limiting language of 3, which is the limitations of actions provided in subsection 1 do not apply under the following circumstances, meaning the statute of repose and the statute of limitations do not apply. So in my mind, you got to figure out, just like under section A and B, what is the statute of limitation? There is no statute of repose, but the statute of limitation is different. And I don't see anybody really taking that on other than the plaintiff, I guess, is in some way. But that limiting language in section C,
So if
it
I'm
says the limitations do not apply.
Correct. The government's position is that if 3C is met, the statute of repose is of no moment, that 3-year limitation in subsection 1. But I will note, Your Honor,
Okay,
that
if 3C is met.
right.
Okay.
But 3A and 3B are a little bit different. They say the limitation of action doesn't apply, back up to subsection 1, but they have a new statute of repose period. How do we know that? Because
It's not a statute of repose according to the Colorado Supreme Court. It's a new statute of limitation.
well, it starts from the act or omission. So it restarts that statute of repose for 2 years. And that is a completely different text than the General Assembly decided.
Not what the Colorado Court of Appeals or Colorado Supreme Court said, though. They definitely said there's no statute of repose now under A and B. I just think, do you see what I'm saying?
I don't think I'm entirely following, Your Honor,
Well,
because
that's the way I read the Austin case.
the way that I read Austin is this, that in these 2 certain types of medical malpractice cases, these foreign object and knowing concealment, we're going to operate the statute of repose a little bit differently. And we can come up with many reasons why that would be why that may be the case. According to the government, there's reasons why there are barriers to discovery in those sorts of cases. And so in those circumstances, instead of accrual as the important date, it's discovery of the act or omission. And that's slightly different than accrual. And so in that scenario, 3A and 3B, they start from when you actually know about,
Statute of limitations.
that's the statute. When you say statute of limitations, I think the government would push back and
Is it accrued?
For purposes of subsection 1, it accrues when on the date that the injury and the cause were known or should have been known.
And when does it accrue? The statute of limitations under A and B.
Same date, but the statute of repose is from discovery of act or omission. So for instance, one example could be, let's say you didn't know that a sponge was left in your body after a surgical procedure. You have no injury, you still don't know about it, nothing has gone on, but then you get an email that this happened. You would have learned at that point, you would have discovered the act or omission. You may not have an injury, but that still is important for purposes of 3A and 3B. So I think that that discovery of the act or omission and then the accrual date, those are separate triggering dates. So it's important to separate those out. And what's really crucial is that after Austin, the General Assembly could have created a rule just like 3A and 3B and put that for negligent misdiagnosis patients in C. The General Assembly did not do so. The statute of repose operates differently in 3C, and I think that the difference in language is really telling here. I do want to touch on preemption briefly, though, before we get too deep into Austin. The government's position is that this really isn't a preemption question to decide here. The Supremacy Clause doesn't need to pick a winner. The FTCA only waives sovereign immunity to the extent a private party would be liable. So in this regard, we can sort of think of a two-step process. And the first step is the state's substantive law. Is that satisfied? Then, once the state's substantive liability is satisfied under that step 1, then we get to step 2 and wonder if the procedural requirements of the FTCA are satisfied. Step 1 was not met here. So the FTCA is of no moment. A few circuit courts have described it that way. There is no clash that this court needs to resolve. But even if this court were to take the preemption question on, I think the CTS Corp case from the US Supreme Court has recognized that the degree of specificity with which you define a statute's purpose is pretty important for this preemption question. And while, of course, the purpose of the administrative exhaustive requirement is to put these sorts of claims in front of the agency first, the broader FTCA is a statute that waives sovereign immunity only to the extent a government would be liable if this was against a private defendant. So I think that that broader purpose needs to be considered. Even if you narrowly consider just the purpose of the FTCA's administrative exhaustion requirement, this is actually an easier case than some other circuit court cases have dealt with, because the fact of the matter is the agency filing was not before the statute of repose period concluded. It did not occur till after. So in this case, it wasn't as if that agency process was cut short or hurried along, because it was already outside of the statute of repose.
Well, sure. So she finds out the day before the statute of repose expires, according to Judge Melgren, that the cancer has metastasized. She still hasn't seen an oncologist, by the way.
Right.
And so, yeah, she had, while she's dealing with this new news that, oh, by the way, I have metastasized cancer, so she could have filed that administrative claim the next day, and, well, on February 1st, and so she didn't, so, I mean, that can't be the law.
Well, I think that,
I mean, so she waits, let's say, so you would have had the same argument if she waited 48 hours after finding out her cancer metastasized, or 1 month and 2 days after she found out that she had cancer. And she had 32 days to file an administrative claim.
so I think that some cases have recognized perhaps there is more of a tension for purposes of the procedural requirements of the FTCA and statutes of repose if that agency filing was made inside the statute of repose period. There is some tension there, but this court doesn't need to decide that case because that's not what happened here. This court could reserve that question, just as Bennett did. In footnote 9 talks about how that is a different sort of factual circumstance that's not presented here.
Well, Benton is our case. Benton, what the court held open is if the claimant has a very short window in order to file an administrative claim, and that's what I'm trying to say. I don't think you would quarrel with the fact that this fits precisely within Benton because she only had either 2 days or 32 days to file an administrative claim.
Right, I think 32 days is is the government's position. It was 32 days to file this SF 95. And I think that,
32 days when she hadn't even spoken to an oncologist about the etiology of her cancer.
right, and I think that that just comes back to,
How does she know? How does she know what the source of this cancer is? Particularly here, where in the past 2 years, she's had multiple misdiagnoses, apparently.
so
This cancer, although
right.
you're only talking about the first one here, but how would she possibly know, having been misdiagnosed apparently in February of 2017, and then at least a couple times more, at least 3 other doctors apparently missed this. And certainly the person who did the mammogram, the radiologist who read the mammogram and the ultrasound missed it. How is it that she's supposed to know on December 31st, 2019, when all she knows is this tumor is now cancer? How is she supposed to know the etiology of that? How is she supposed to know that it's the same lump that she was told was a cyst in 2017, that she was told by the radiologist who read the actual mammograms and ultrasounds in 2018? How was she to know that day? Oh my gosh, that was from that misdiagnosis back in 2017.
So the
At a
government,
minimum, how could she know before she talked to the oncologist? And who knows if she even knew then?
so the government takes a different view on what is,
Let's accept that there was a question of fact about when she knew of the cause.
then under Colorado law, that would not be appropriate for summary judgment.
Right.
But that,
Could we go there and avoid all of these questions?
that is one way to resolve it, Your Honor, but I would really push back on that she knew it was the cancer from 2017 that was still persistent. The fact of the matter is,
She didn't know is what I'm saying. How was she to know?
right, and so when we look at medical malpractice cases, and particularly in the negligent misdiagnosis context, there will always be a condition that the plaintiff sought treatment for in the beginning. That condition was a lump.
There's usually not a condition in a cancer case where there's been multiple misdiagnoses of the same lump, and it's the patient who is super diligent and continues to say, I got a problem with this. I got a problem with this. Will you please biopsy this? Has to ask multiple times to finally get the biopsy. That is not the typical case. And that is the facts of this case, which I'm suggesting might mean that there was a question of fact as to whether she would have known which diagnosis was the problem.
If that is one way to resolve the case, would be the summary judgment concern about cause. But again,
Press those facts,
so the
not the
McCulloch,
general case.
Certainly.
These facts.
the McCulloch case, I think the differences in the McCulloch case with this case helps us. Because in McCulloch case, the plaintiff knew at the first appointment after the fact that she had cancer at that first time, and that was a negligent misdiagnosis.
But
So
we don't have those facts in this, the facts we have here in that case.
precisely. So
Where you've got a 2-year odyssey of trying to diagnose this, trying to get it diagnosed, trying to get a biopsy. Only the person who's not a medical professional pushing it. We don't have those facts in any other case that you've cited.
exactly, and that's how we know that the condition changed over time. Because what we know from this summary judgment record is that when she saw nurse practitioner Trexler on February 1st or 7th, 2017, she went on that date. The lump, as she was told, was nothing to worry about. So that is the condition that she sought treatment for. Over the years, that condition changed. The lump changed and changed and
Same lump,
changed.
the same lump.
Well, we don't know that necessarily from
But
the,
how was she to know that is my point. You're suggesting she had to know by February 1st, or certainly by December 31st of 2019, that what the cause of her injury was.
so the Colorado
How
court.
was she to know that?
Colorado cases have been clear that you don't need to have an expert opinion weighing in that this negligent misdiagnosis from 3 years ago,
Of
that's
course you
definitely
don't, but
what.
this is a fluid situation. She hasn't even spoken to the oncologist yet.
Right, but she has facts available to her. And what's particularly meaningful
What facts did she have available?
as of January 1st or January 6th, 2020, she remembers back to that 2017 appointment. And she recalls that in her deposition and said, this I had forgotten about, this whole process I had forgotten about that first appointment with nurse practitioner Trexler, but she links it back inside the repose period.
Also had a mammogram and an ultrasound after that, and she remembers that too, and they told her she didn't have cancer either.
Again, this is all,
She to know that that was the mistake, the February 1st, 2017.
so I
Misdiagnosis
would
was
push
the
back on this mistake concept, because I think that that comes back to, she had to know the tort liability. I think it's actually facts. What did she know? She knew that the lump went from being non-cancerous, over time, it became cancerous. That is what we're talking about as the injury. That's the worsening of the condition.
And you're saying that was a change?
Right, because at that first appointment, she was told it was
So-
nothing to
so-
worry
so
about.
let, I hope I'm not interrupting. So I just really am trying to follow up on Judge Moritz's question. So if we're looking at the statute, the Colorado statute, so if it changed, and how can it possibly be that the statute of repose is triggered pre-change, February 1st, 2017? Why not January 6th, 2020?
Because that's, Your Honor, what subsection 1 says, the act or omission.
Exactly. So but in no event shall an action be brought more than 3 years after the act or omission.
Right.
Which gave rise to the action. And then in C, if the physical injury and its cause are not known or could not have been known. Now, whether or not we interject the 3 years that the district court did or not, it couldn't have begun on February 1st, 2017, because it couldn't be known because it changed.
Well,
That's what you said.
well, I'm not sure I'm following, Your Honor, because we're accepting the amended complaints allegations as true, and I see them out of time. I'd like to answer your question.
Yeah, I'd like you to too. So-
Assuming that
so
nurse.
You're saying that that the condition changed. And so I'm really not trying to trick you or anything. I'm really just trying to understand it. So if you're saying the statute of repose began on February 1, 2017, and then you're also saying, in response to Judge Moritz, well, the condition itself changed. It wasn't a benign lump on February 1, 2017. It changed 25 days before the statute of repose would have expired, January 6, 2020. And so how can it possibly be that the act or omission giving rise to the action would have existed on February 1, 2017? Because that's not even the condition that existed that you're saying spurred the action. You're
Because
saying that the condition that spurred the action, you're saying happened on January 6, 2020. So wouldn't the act or omission have begun on January 6, 2020 under your scenario that the condition changed?
No, Your Honor. I think this is because a fundamental disconnect between act and omission is one thing, and injury and its cause are another. The former act or omission pertains to the statute of repose. It sets a hard deadline. As some cases have recognized, the statute of repose could be extinguished before someone even knows they have a claim, and that's because act or omission, the alleged negligence, is totally separated from discovery of the injury and its cause. So in this case, that is entirely possible that the act or omission, i.e. the alleged purported misdiagnosis that occurred in 2017, is separate from when she knows about the injury and its cause. That's how those can be reconciled.
understand that. Thank you.
Counsel, can I ask, does the government agree that the accrual date here is a question of fact?
Ordinarily, but in these circumstances, because the facts are undisputed, it can be decided as a matter of law.
Okay, so help me with that then. I understand that under Colorado law, but in Ms. Lewis's brief, I believe that they presented it was a question of fact. I did not read the government contest that in response. I may have missed it, but I'll give you that opportunity now. So help me understand why here it's undisputed, the accrual date, when all I hear is a pretty excited dispute over the accrual date.
I don't think there's any dispute as to when Ms. Lewis knew what, because her deposition says so. On December 31st, she was informed that she had cancer. On that date, she knew of an injury.
Did she know that it was the same lump that Nurse Drexler had looked at on February 1, 2017, or is?
It was in the
is
same
that a fact?
location.
Well, yeah, but that's not my question.
Right.
Or is it a fact question about whether or not it was the same lump that she learned about in January 2020, whether it was the same lump that was looked at by Nurse Drexler?
And that goes to my point of course she didn't know when she was told several times more by several doctors that this same lump that she kept presenting for was not cancerous and even had scans. So how was she, a layperson, supposed to know the day she's told she has cancer that all these people apparently were wrong, but it was that very first person, this is that same lump, and somehow all these people were wrong, and that same lump must have persisted through all of it. Is that a question of fact? It sure sounds like it.
But that was a litigation choice, right? To decide that it was nurse practitioner Trexler whom she wanted to sue.
But the fact that she has confirmation over and over that that lump is not cancerous, the same lump she's presenting for, certainly factors in to the issue of when she would have known that the cancer she's told she has that has metastasized resulted from the same lump, because cancer doesn't get non-cancerous. It was either cancerous then, or it's a different lump.
Right.
And that's possible.
Right. And so I would just.
But she's told over and over that that lump isn't cancer. But you're saying she should have known the day she's told, finally, it is cancer, that it was that very first diagnosis where this all went awry.
So I guess I agree on a few different points, and I recognize that I'm quite over time, but I would like to answer them if it's okay with the court. So I would push back on the fact that the injury and its cause that she has to know has to be the proof positive that this person, had they done something different, I definitely wouldn't have cancer. Those are what experts provide at trial. That's just not necessarily what is required in order to know the facts for purposes of accrual. Otherwise, it would be hard to litigate any accrual concern at all, because without experts that come in trial, we would never know that. So again, the condition for which she sought treatment was the lump. According to her, a complaint and then the amended complaint, that lump was what turned into cancer. So that pre-existing condition was what got worse during the course of the repose period. Within 3 years, she knew about the cancer diagnosis, which is the injury here. And within 3 years, she connected it back and said, oh, I remember that appointment. There is not much need to know more. She doesn't need to know specific legal theories for.
Whether the lump is the same lump that she's been told over and over again by several physicians isn't cancer.
Well, the complaint alleges that's the case.
That complaint gets filed later. We're talking about
Certainly.
what did she know on December 31st?
So I think that.
You're saying a layperson should have known that on December 31st, not that her lawyer should have known it when he filed the complaint.
Right. There are numerous Colorado cases, and I think that they're cited well in our brief, and I know that I'm very over time still, but that have just talked about how the legal theories is what's not required for purposes of accrual. It's knowledge of facts, and the facts for purposes of the elements of a negligence claim. And here, those facts were known inside that 3-year period, and under 3C, therefore, that repose period stood.
Counselor, can I bother you with one more question?
It's not bothering, Your
Well,
Honor.
I was going to say, I accidentally interrupted Judge Federer.
I think this one may be a short one, though. Is this statute an affirmative defense under Colorado law?
I believe it is, yes.
How do we factor that into the summary judgment analysis?
You know, I'd have to think about that, Your Honor. As long as there are no disputed facts as to whether or not it applies, then yes, indeed, you can decide it as a matter of law. And again, the record is all the facts are clear in terms of there's no dispute as to maybe she didn't get the cancer diagnosis until March. No, that's not the case. It was on December 31st, and because we have these core agreed upon facts, I think that this still remains as a question of law.
Sure. Thank you.
Okay.
To your point, Judge Moritz, I think the court can look to Salazar versus American Sterilizer, where the court said Suspicion of a possible connection does not necessarily put a reasonable person on notice of the nature, extent, and cause of an injury. If Ms. Lewis's surgeons, both of them, could not say what the likely progression was, whether it was related to her diagnosis years before, how could Ms. Lewis as a layperson do so? Real quickly, within the 30-day period, the fact that Ms. Lewis didn't file in that period is irrelevant from our perspective because.
Go ahead, you can finish.
Because conflict preemption, when it relates to impossibility, the law doesn't require one to attempt the impossible to argue that. Further, when it concerns obstacle preemption, the question is congressional intent, not whether a particular plaintiff could have acted faster. So with that, Your Honor, we would ask this court to reverse the trial court's grant of summary judgment. Thank you.
All right. Thank you very much. It was very well presented by both sides. This matter will be submitted. In the last case is Friends of Animals versus Fish and Wildlife Service, 254021. Give me 1 minute. Can somebody shut that door? Thank you. All right.
Hello. All right. Good morning, Your Honors. May it please the Court. My name is Andrea Marcuccio, and I represent Appellant Friends of Animals. I'd like to reserve 2 minutes for rebuttal. This case is about a conservation plan that conserves almost nothing. It prioritizes development at the expense of a species threatened with extinction. The U.S. Fish and Wildlife Service issued master incidental take permits based on a general conservation plan that lets the counties approve future development that will permanently destroy habitat across the Utah prairie dog's entire range and take over 7,000 individuals, all without identifying a single colony or an acre of habitat that it plans to protect. Today, I'll focus on 2 critical ways that decision violates the Endangered Species Act. First, it was irrational for FWS to conclude that the mitigation or that the harm would be fully offset without assessing the biological value of what will be lost versus gained, and instead relied on so-called mitigation that kills more than 90% of the animals involved. And second, it failed to require known practical mitigation that would reduce take. And if I have time, I'll also address how the record directly contradicts the no jeopardy finding and the funding finding. For these reasons, we respectfully ask the court to vacate FWS's arbitrary decision. So moving to the first issue, the Endangered Species Act requires that the counties minimized and mitigated the impacts to the maximum extent practicable. But
only if it's but that's only if the take is not fully offset by mitigation measures, right?
yes.
Under the handbook.
Yes, Your Honor. So based on the handbook, there's 2 ways that they can do that. Either find that it's fully offset, or they could find that no more practical mitigation would reduce take.
Okay.
So here, FWS claims it met that requirement by finding that the impacts are fully offset. So if the court rejects that finding, then it violated the ESA. And there are 2 major problems with that finding. And its first is that they couldn't reasonably conclude the impacts would be fully offset without looking at the biological value of what would be lost and what would replace it. The recovery plan repeatedly emphasizes that Utah prairie dogs can only survive and recover if FWS identifies and protects valuable habitat that keeps colonies connected, especially on non-federal land. It explicitly directs conservation plans to do that. And FWS's handbook confirms this by defining fully offset to mean that the biological value lost must be fully replaced by conservation measures with equal biological value.
One thing I didn't understand from the materials, let's say I'm in Iron County and I want to open up the Bob Baccarat condominiums on a major development area. And so Iron County has this now, this master permit. And so I send an application, I send a biological map, I say exactly what I want to do. Now, does Iron County then determine whether or not there are adequate mitigation measures to fully offset the permanent destruction of habitat that's going to happen through the Bob Baccarat condominiums?
Your Honor, so under these type of master permits, there is, in major development area, no habitat quality assessment is needed before take occurs. And in minor development areas, they do require a habitat quality assessment, but that's only used to rate the habitat, and it's just kind of to track the mitigation success of the GCP.
But then why are the applicants for these developments submitting these applications for a certificate of inclusion, or if there's not a master permit, for an incidental take permit, you know, with all of this information about the biological habitat that's going to be destroyed? Now they say, well, I think what they imply is that it's going to take place later, the comparison between the biological habitat that's permanently destroyed versus the habitat that's going to be available on federal lands, for example, through a relocation and the like. So are you saying that despite the fact that an applicant for a certificate of inclusion or for an ITP submits this material, that nobody ever actually looks at it, they give you a certificate of inclusion and then worry about what they're going to do later?
Yes, Your Honor. For major development areas, there is no habitat quality assessment done. They might say where the location is, but there's no assessment of the biological value of the colonies and habitat in that area. And that is described on 3JA 211 and 220. And so the counties won't ever know what that quality is that's being lost. And they do require them for minor development areas, but again, the UDWR looks at these assessments, not Fish and Wildlife Service, and they just report it to Fish and Wildlife Service. It says that it is only to track mitigation and not to change any mitigation here. So under this plan, the mitigation is already set by the GCP. There's no more additional mitigation that will be changed in the future. It's just the kind of structure of this is that the mitigation is already fully offset now, and all that the developers have to do is basically just apply for the certificate of service. They just have to say that they're going to comply with the GCP, which is just to translocate if feasible, and they pay their fees. There's not any more habitat quality analysis done.
Counsel, can I pick up on a word you just used, which is the structure of all of this? Because you're not challenging, as I read it, individual permit request decisions that are made by the master permit holders. You're challenging the general conservation plan, which Fish and Wildlife said is more at a landscape level. And as I read the district court's order, it kind of took you to task to say, well, you're not understanding that this is at a landscape level, the conservation plan, and so all this information that may be deemed deficient, of course they wouldn't know that when they authored this plan because it has to be decided later. And so I just find myself struggling to understand how that makes a difference to our analysis here when, as I read the requirements of the statute, it doesn't really contemplate, as I read it, a difference between these general conservation plans and the habitat conservation plans. But yet in your reply brief, you said, well, we have no issue with them doing it this way.
Your Honor, so we aren't challenging the programmatic structure of the general conservation plans, but this GCP was FWS's one and only chance to assess the biological value and the impacts and implement more mitigation before these colonies are permanently destroyed. Under the ESA, anyone applying for an incidental take permit must submit a conservation plan, and FWS has to make these findings about it. Under these master permits, like this general conservation plan is the conservation plan for that. It could not have been, the permits could not have been approved without it. And FWS will not review or approve any future development. There is some reports after the fact, but that is after habitat has already been taken. They just say that they treat all allowed take under these certificates as already fully mitigated and already addressed by the original GCP, the original NEPA analysis, and the no jeopardy finding. There is not further review, and I do believe that that is where the district court misread those facts.
So there's never a biological review. Is that what you're saying?
Not by Fish and Wildlife Service, no.
And you're saying that by their terms of their own handbook, by the terms of their own handbook, that's required?
Yes, Your Honor.
Pre-permit, I mean, you say you're not challenging the structural or the programmatic aspect of this, but it seems like you are.
We
in
are
the sense that you suggest that this needs to be before the issuance of the permit.
But, Your Honor, the permits are already issued. These master permits are incidental take permits under the Endangered Species Act.
Right. And you're not challenging the fact that those master permits are issued. You're not challenging the structure of that?
Your Honor, we are.
Like you are, and that's,
yes.
I kind of thought maybe Judge
Sorry.
Federico was going there too. That's my struggle as
Okay.
I was reading the briefs is you insist that you're not challenging it, but then you seem to be challenging it.
Your Honor, we are challenging the master permits. We are not challenging future certificates of inclusion that the counties will eventually approve.
So your position, as I think heard you articulate it, is that Fish and Wildlife Service has to make these determinations about, whether or not these master permits, as they are being given out to counties, comply with the requirements of their plan and then therefore the statute. But again, I think the district court says, well, how could they at that point in time? Because they don't even know what the projects are, where they're located, and what the potential take and mitigation would be.
Well, Your Honor, there's ways to mitigate the impacts to the maximum extent practical without knowing the location. That is why biologically based mitigation was required here. The recovery plan directs them to protect valuable habitat, and they could have mapped out all the habitat and said, no development in this area. And then they would know that the biological value of what's being taken isn't high quality and important for recovery and survival. And consistent with its own handbook, it could have said that, it could have required that lost high or medium quality habitat be replaced with either more or better quality habitat. It chose not to. It instead just labeled the areas as major and minor development areas and used this mitigation ratio of conserving 1 acre of habitat for 1 loss, but that tells you nothing about the biological value of that habitat. And its handbook has many examples where they will say if this quality of habitat is lost, it must be replaced with this quality of habitat, and none of that happened here. There were just so many ways that they could have protected valuable habitat and still comply with the statute, but they did not do that here.
And complied with the programmatic structure that they've set up here?
Yes, Your Honor.
Okay.
And
they would have done that pre-permit?
yes, and that would be by implementing this mitigation that does consider these biological values of colonies and habitat, like exactly what its recovery plan tells it to do. And instead, they just relied on these translocations that are overwhelmingly unsuccessful. FWS itself said 90% of prairie dogs will die within a year and 2/3 of sites will completely fail. that means that the mitigation itself results in take. So there's no way that these impacts could have been fully offset. And its own handbook says that translocation should be used sparingly and only with further research. And the record confirms that the new colonies that will be created through these won't fully offset the loss because the GCP deems translocation sites successful even if all prairie dogs die on 2/3 of the sites and the remaining 1/3 have a spring count of just 1 prairie dog. But the science shows that to maintain viable colonies and that the colonies need to remain connected and have a spring count of at least 20 prairie dogs. Otherwise, they contribute little to the species' long-term persistence. And I see,
Council, can I ask you one quick question on remedy? You're arguing for us to vacate the plan, but if we found that there was, maybe problems with the plan, why would we not remand for a vacatur decision by the district court?
Your Honor, the court should vacate and remand the GCP and permits because this is the presumptive remedy for violation of the APA, and there's no reason to depart from that rule here. These are serious and not easily fixed issues, and if there are any questions on remedy, we would request some further briefing on that. And I see that I am cutting in my rebuttal time, so.
Robert, why don't you stop the clock? Rich, did you have any questions? No. Thank you.
Thank you.
Good morning, Your Honors. Amy Collier on behalf of the U.S. Fish and Wildlife Service. I'd like to start by addressing a little bit of misconception, I think, between the mitigation with the major development and what the agency is considering there and the mitigation for the minor development areas. So Fish and Wildlife first looked at the entire mapped habitat across this entire range. And you can look at those maps. Don't have the site in front of me, but I think it's 3JA 121, 122. Looked at the maps, looked at the areas where there is already development or areas adjacent to developed areas that Fish and Wildlife determined there might be prairie dogs, but those prairie dogs aren't important to the long-term survival of the species in those locations where they are now.
You're right, because, I think you say it on 59, because these are built-out areas or adjacent to areas that are going to be built out, which sounds like the prototypical definition of a circular arc.
Well, I see that there's planned development there, but it's also areas that are already developed, that the habitat is fragmented, that there isn't that connectivity that you might find in the minor development areas or the less developed areas. So you have these sort of isolated prairie dog populations.
But at least as far as the areas that are not yet built out, that argument is circular.
Sorry, I missed what you.
For the areas that are major development areas that are not already built out into condominiums or into an existing development, your argument is circular, right?
Well, no, I don't think so, Your Honor, because I think in the places where they're adjacent, and you can look at the maps, you can look at where they designated these major development areas. Those places, if there are colonies there, they are isolated from the greater meta population as it stands.
But you also are saying in the GCP that the major development areas are the ideal site for the colonies because the federal lands are arid, and these major development, if you want me to find it, I will, but the major development areas are areas with prime vegetation. They have lots of moisture sources, and so explain to me how it's not circular.
Sure.
To say, because we're going to give these master permits and these ITPs, how is that not circular?
So I think the distinction there is it's not the major development areas that have the good habitat. It's the minor development areas, private land, still non-federal land, that might be more agricultural, might have more moisture, might have lower vegetation because they have those agricultural practices. Those areas might serve as good habitat long-term. And that's why the agency looked at those areas and determined that, for development that happens in minor development areas, we're going to offset that by protecting in perpetuity land that's private land elsewhere at a greater than 1-to-1 mitigation ratio. So that's,
All right, so which of the sites for the major development area in the federal sites, which of those are, or could you tell me where in the GCP or in the findings or the biological opinion, FWS ever says, this is a good area to put 400 Utah prairie dogs on?
which of the areas in the major development or in?
In federal land, for either a minor development area or major development area, for your mitigation of translocation, where have you ever said, this is a good site to create a new, you say you're going to create 3 new colonies? Where?
Sure. So they discuss the conservation banks. It identifies 3 specific conservation banks that have up to 311 acres potentially for offsetting impacts elsewhere.
And that's in the GCP?
Yes, that's at 3JA 62. In terms of federal land, it talks throughout the GCP, and I apologize for not having the site right
Where
now.
on page 62 does it tell me this is the location that we're going to create these new colonies on federal land? I'm
Okay, so
looking at
that's the
62 and I-
conservation bank. That's protected land, but not federal land. I don't have the site in front of me where it tells you the specific areas of federal land where the translocation colonies would appear, but they have been maintaining translocation sites on federal land for decades. They've been adding prairie dogs to those. They've been both creating new ones, but then also ones that have been depleted, adding prairie dogs back to those sites.
And you're saying that I think it's on table 11, that you're gonna, I think it's 1,714 prairie dogs, Utah prairie dogs, on these sites that are gonna be translocated, and you're gonna take this figure out of those 3 years of Iron County, and you're gonna say 71% of that 1,714 prairie dogs are gonna be translocated. Then we're gonna step that up with a multiplier of 5. So we're going to have like 6,000 prairie dogs. Why is that wrong?
I don't, so
How many prairie
stepped-
dogs are you going to relocate?
the stepped-up estimate estimates that over the course of 10 years,
Right.
5,466 prairie dogs will be
All right,
translocated.
and so have you ever said where these prairie, other than saying I'm going to put, trust me, we'll find federal land that has great vegetation, that's got great liquid sources for these prairie dogs. Where have you ever said that there are enough sites, would you say 5,000?
5,000 over the course of the
Oh,
entire 10 years.
So
So
in 10 years.
500-ish a year
and-
under
and
the
you
stepped
can't
up.
put more than 400 prairie dogs in a colony, right?
Right.
So where have you ever said in the next 12 years, we have 12 sites on federal land that we can put, that we can move these 5,000 plus prairie dogs?
So
From a biological perspective, will be equivalent.
So I think we need to step back again and look at the framework that the Fish and Wildlife Service is dealing with here. Again, this is the maximum potential amount of prairie dogs that would be moved. Under the expected amount, it's much lower. And Fish and Wildlife left that analysis in there to sort of give a better understanding of what they expect they will actually accomplish over the course of the year.
Okay.
But
Well, so the five times the stepped up amount is, we were kidding, you know?
it's not that we were kidding. That is the maximum amount of take that could happen over the course
That's
of
what
10
you
years.
expected. That's what the GCP.
That's not
said.
what's expected. That's the maximum cap on take.
Okay.
The expected
so you
estimate,
have a maximum cap of 5, I'm not trying to argue it, but you're saying that the maximum is we're gonna have over 5,000 prairie dogs that we have authorized. If Friends of Animals wants to come in 8 years later, you're SOL. We have authorized now in this GCP, the transfer relocation of up to over 5,000 prairie dogs. And so I'm not asking a terribly complicated question. I'm just saying, where are you going to put these 5,000 prairie dogs?
so I would direct the court's attention just towards the discussion of how the agency selects translocation sites, the history of setting up translocation sites and the improved success. So that's at 3JA 67 is where they're discussing about how they've used the sites. It also discusses,
I mean, you've got all sorts of stuff about how you're gonna do this. That's, you know, if you don't have an answer to my question, I'm not trying to be
No, I-
argumentative, but you see, and you can defend saying, well, we hadn't done it, but I'm just trying to know, are they right or wrong when they say that Fish and Wildlife Service has never said that we have 1, 2, 3, 4, 12 sites that we can relocate 400 prairie dogs?
I think that is factored into the analysis of the agency determining that there would be 71% translocated, that there would be new colonies of 400 acres and 3 new colonies of 400 acres on the stepped up. The point that the analysis here, of course, is at a general level.
Judge Morris.
Well, I think you're not addressing what I think the problem is. It's not about the numbers that you came up with. Here's how many will be transferred. Here's the maximum take. It's about the quality of the assessment.
Yes.
Especially as to mitigation, but, you know, there has been no biological determination of the quality of these colonies, the numbers of because you don't know.
For the translocated from major development areas or for minor development areas? 'Cause I think those are
major, aren't
So yes, for mitigation for major development areas, the plan creates new colonies on a one-to-one level on protected lands.
But you don't
Fish and
know what the
Wildlife-
quality will be.
But Fish and Wildlife already determined that the major development areas don't have quality that is habitat quality that's important to the long-term survival of the species.
Where
We're
do you say
replacing-
that?
Yeah.
Now, you have said that the major development areas are not a long-term source that is viable, I think it was on 59, because
Of development.
we're gonna expect a lot of development.
And because there's already development there.
There's nowhere in the yeah, right, okay.
Where
but
do you
there's-
actually look at the biological aspects of the colonies that are in the
So,
major development?
So I think to step back a little bit, Fish and Wildlife applied 2 different offset ratios for the major development and minor development areas. For major development areas, the agency realized we're replacing occupied habitat in these major development built-out areas that aren't important to the long-term survival of the species with occupied habitat that wasn't previously occupied habitat, but newly occupied habitat on a 1-to-1 ratio on federal or protected lands. That they determined was a biologically offset, again, applying their expertise.
What is the quality of the newly occupied habitat?
The fact that it's protected in perpetuity, that the agency will
Talking
also.
about the biological.
Sure, so the translocation program, and if you look at the various provisions that are required as part of the translocation program, involves a ton of money that is spent.
I'm not talking about the money that's
No, but
spent.
that's
I'm not talking
important.
about the funding. I'm
Because
talking
that
about
goes-
what you know ahead of time.
These
about
sites are
these
treated
areas.
for plague, they have vegetation treatments, they apply these aspects to these particular translocation sites to improve the habitat,
So it
to
doesn't
ensure better
matter.
success.
What you're saying is it makes no difference what the size of the colony is. It makes no difference what the quality of the colony that'll be transitioned is. You're going to make sure that the mitigation area is sufficient.
I think the size does matter. They measured out the 400 acres. That's the size that the goal for the translocated colony is. They determined that we're going to be applying these particular measures to improve the habitat quality, to make sure it's sustainable for the species.
Don't know where it is right
But we
now.
don't need to know yet where it is. That's sort of the
You'll make
overarching.
it just exactly what it needs to be.
Well, again, I don't know who you'll make it, who that's applying to. Fish and Wildlife is
Then
not.
it will fully offset. I mean, that's the choice of the agency.
Yes, the biological
Mitigation will
determination
fully offset.
offsetting a colony on, or fragmented habitat on major development areas with a sustaining colony of 400 acres on protected land that will be protected in perpetuity and will be treated with various treatments to improve the habitat quality. Take into consideration things like connectivity with other colonies. Take into consideration the size of that colony, how close it is to other smaller colonies. That's all that's going to be factored in. And I'd like to push back a little bit on the fact that Fish and Wildlife is having no role going forward once it issues these permits. At page 3JA61, it talks about how the Fish and Wildlife and the Utah Department of Wildlife Resources will together evaluate habitat quality for mitigation, will determine the offset ratio that's appropriate for minor development areas.
Okay, so can I ask you the same question that I asked Friends of Animals, and that is, does Fish and Wildlife or the Utah Department of Wildlife Resources, is there any analysis of comparing the biological habitats of the sites that are destroyed versus replaced prior to the issuance of a certificate of inclusion?
Yes, so when a permit.
Where do I find that in the GCP?
Yes, so the permit process and requirements is at 3JA 204, that's where it starts. And it details how a permittee will apply for a certificate of inclusion from the county or the master permittee, whoever that is. They have to first do, if they're in the clearance area for, basically if it overlaps with habitat, prairie dog habitat, whether occupied or not, or within the clearance area, they have to do a survey to determine if there are any, have a qualified biologist do a survey to determine if there are any prairie dogs even present. If there are ones present, then they also have a biologist do a habitat quality assessment for minor development areas.
On 204, what I don't see, and maybe I'm just overlooking it, is where, this provision, 1.0 master permit holder process, ever says that the Utah Department of Division of Wildlife Resources ever does a comparison after they get all of this biological data to make sure that there's full offset, let's say on Bob Bacharach's condominiums.
Yeah.
I just don't see that on page 204,
So
205.
there's annual reporting that the State Department does. They gather all the information about the location, size, quality, and I see.
But that's not prior to the my question is about prior to the certificate of inclusion. Now, if you're talking about annual monitoring, you've got a lot of stuff about annual monitoring.
Yes.
I just want to know, prior to the issuance of a certificate of inclusion, where does it say on 204 and 205 that the Utah Department of Wildlife Division of Wildlife Resources is going to do this comparison of biological habitats prior to the issuance of a certificate of inclusion?
So that is, I don't know if it says it on those pages, but it does say it when it talks on 3J 61, where Fish and Wildlife and Utah Department are making sort of the determination of what would the offset ratio for that particular project would be. Now, I acknowledge there's a fair amount of flexibility in here. That's the design of the plan itself, which I understand plaintiffs not to be challenging. The benefit of this program here is that it has that flexibility. It's on a bigger scale so that the agency can look at, both project by project, but then with that annual monitoring, that 3-year monitoring, determine whether check in, see if the measures have been the mitigation is fully working, see if it's been effective, and if it's not being effective, are there things we can do with raising the fees to get more money to buy better habitat quality habitat to offset these losses, that there's sort of that continuing on check-in process. So it might not be immediately the second that the certificate of inclusion is issued, but there's this ongoing process to make sure that the take that's occurring is fully offset through these other provisions. And I know I'm out of time.
I just wanted to ask, because I just feel like I'm missing this, but what's the justification for requiring a habitat quality assessment for minor development areas but not major development areas?
So again, that goes to Fish and Wildlife's expertise determining, looking at this species and saying, this is not, and this is in the recovery plan, that these areas are not important to the long-term survival of the species. The mitigation measure there is not to replace that lost habitat with habitat of a particular quality, so we don't need to know the particular quality that's being replaced. The mitigation there is to create new colonies in places where there hadn't been colonies to fully offset the take of colonies on major development land. And this, again, goes to a point that these are the experts applying their expertise. Weighing biological value is something that the agency does every day, and I think, sometimes as lay people, we don't necessarily understand that balance, but they do, and they've been managing this species for decades and decades, and it's continued to improve over the course of that time with habitat conservation plans in place.
So I have one more as well. As I understand, the fully offset route that the agency has determined to take, how do you compare full offset to what I think I read was how you were going to define translocation success, meaning there was this objective to translocate 120 to medium to large colonies onto federal lands, but then the estimate, again, maybe I have this off, but was that maybe only 3 small colonies would actually get translocated successfully in 10 years. So how do I look at the goal of full offset compared with that estimate of what is defined as success and find those two concepts to be in alignment?
So I'm not sure the numbers are quite right. My understanding is that the mitigation for major development areas is to create occupied habitat of, under the stepped up estimate would be 1,200 acres, which would offset the 1,100 or so acres of major development, habitat destruction through development in major development areas. So it'd be greater than that 1,100 amount.
So the full offset, you're measuring in acreage, not dogs.
Yes, and I think that that's what the agency has explained throughout the recovery plan and with this as well, is that this is a species that has a very short life cycle. Its measured success is often based on the extent of its habitat because there is just quite this bit of turnover and quite this bit of fluctuation from year to year. The agency pointed out that the annual fluctuations in population for the species can be huge, and so how they really measure it is the extent of occupied habitat. And I think, again, it's within the agency's expertise to determine that that is an appropriate measure for the biological value for offsetting. And I would like to touch really briefly on the vacatur question. I certainly don't think vacatur is warranted here. If the court does go that way, we would absolutely request that it be remanded to the district court. This plan has been in place for almost 8 years now. It's a 10-year plan. And I know it's not on the record, but the species is doing incredibly well with this plan in place, and it would be incredibly disruptive to vacate this plan and take it out in that sense. And I think that is all I have. If there are any further questions.
So I hesitate to ask this because nobody's talked about it, but I do have a question about the funding. And I want to tie it back to something that you said earlier. So my memory is on page 182 of the GCP that you, not you personally, but your client has calculated the trans relocation cost per Utah prairie dog at $272 per prairie dog. That's based on $408,000 that you say is just a starting point, trans relocating 1,500 prairie dogs, right?
That sounds right to me.
Okay. And so if you take this stepped up estimate that you've authorized, but don't really anticipate, but you've authorized it, of over 10 years of 5,000 plus prairie dogs being trans relocated, how can we say it's not arbitrary and capricious to say, I mean, that's a big number, 5,000 times 272. In other words, even if you take that $408,000 and triple it, that's over $1 million. And okay, fine, the Utah has said, well, we'll provide funding as available, but they've never provided over $1 million. So even over a number of years, have they? At least
not in the
we're
record,
limited.
but yeah.
Well, that's what we're confined to.
But that analysis, again, was looking at the annual cost, and it said that, you know, the annual cost would be, I don't have the number in front of me, but less than what the Utah Department has contributed annually for the last several years. Utah's been doing translocations for 50 years, I think, in this area, and the annual cost would be less than what they've been contributing.
Your whole point, however, is, I mean, this is why you're using the Iron County years for 1998, 2000, and 2001. This is unprecedented, is your argument, as far as the new emphasis that was not available to Iron County in the late 1990s and the early 2000s. That's your point, right? That this is an unprecedented shift in trans relocation. And so how can you say, okay, well, even though we have never experienced this sort of emphasis on trans relocation, they provided $340,000 a couple of years ago, and so we can kind of guess that over 10 years, they'll probably be willing to provide us over $1 million.
So just to clarify, Utah does, and the federal agencies do translocations independent of development, and they've been doing that for many years as well. So I think that factored into the cost analysis too, that the department is committing this money for translocation as a minimization and mitigation measures in this plan. And over the last several years, they've contributed way more than that to translocations generally for the Utah
Maybe
program.
over $1 million?
Yeah, well, I don't know per year over $1 million, but certainly cumulatively over $1 million.
And that's, if we look in the GCP, or we'll find that.
Yeah, there's analysis of how much the state has been contributing to translocations generally, independent of habitat conservation plans. But I would also point out too that, if it turns out that there's shortfalls in any funding with translocations, the agency is continually reviewing the funding from the mitigation measure for minor development areas and whether that standard fee is sufficient. And there's room there to increase that standard fee if we need to adjust the funding across the.
That only goes towards the future developer, not your past developers.
It does, but
That presumes there is future development, right?
I think that's a reasonable assumption to make here. I don't think it's unreasonable for the agency to believe that there will continue to be development over this 30-year build-out for this area, but that adjustment to funding does explicitly say it'll account for any shortfalls in previous years too. Thank you.
So there's a couple points I would like to address. And the first is that if the Fish and Wildlife Service never knows what the quality of habitat or colonies lost is, how will they ever be able to determine that this would be fully replaced? And on 3JA 211, the first sentence says, habitat quality assessments are not required for projects that occur in Utah prairie dog habitats in the major development areas. That is where FWS estimates 90% of the take will occur. And to mitigate that, they will be translocating prairie dogs at a 1-to-1 ratio of unknown habitat quality to areas where they have specifically said are arid and there's competing uses, and they have not said that there's high-quality habitat available there.
What about the response that they're going to make sure that they can turn this into high quality? Low quality can be turned into high quality.
Your Honor, the Fish and Wildlife Service was supposed to make this finding before it issued the permits. It cannot rely on uncertain, maybe we'll make a good habitat quality in the future. To make that fully offset finding, it had to do some type of biological mitigation in advance here. And not only is sorry, I see I'm running low. So not only is their interpretation of major development areas circular, it is also, the recovery plan specifically says that these areas remain critical to survival and recovery. Its own document says, until recovery is achieved, major development areas, quote, retain a high level of conservation value, unquote, because they maintain many prairie dogs and maintain connectivity with minor development areas. So when 90% of the take is being done there, and they're not even assessing what habitat is lost, then there's no way to say that it's going to be fully offset. And these areas contain the major development areas contain 46 medium and large colonies and 5,200 acres on private land. And these are areas that the recovery plans have said are essential to survival.
But counsel, why should this court substitute our judgment for Fish and Wildlife's expertise when they just argued that major development areas are not important to the long-term survival of the species, and that's, their agency expert opinion? Why shouldn't we defer to that?
Your Honor, this is not deferring to a different scientific opinion. This is just saying that they can't reasonably find that the impacts are fully offset when they haven't assessed the biological value here. And even, like, deference isn't unlimited. They still have to ensure the scientific integrity of their analysis, and they have not done so here. And the quality that the habitat quality assessments that opposing counsel was talking about only apply in minor development areas. That page 61 is talking about conservation blanks, which are used to replace habitat in minor development areas only, where 10% of the take will occur. And even then, there's only 311 acres or less available in those conservation banks. So there's no reasonable basis to conclude these would be fully offset. And if there are no further questions?
All right, thank you. I don't think we do.
Thank you.
Both counsel. Obviously, as all cases are, it's very important, and I appreciate the excellent advocacy of both sides. Court is in recess until 9 o'clock tomorrow.